The AP is now reporting a historic decision. The Supreme Court says same-sex couples have a right to marry in all 50 states. Dave Lucas joins us live from the newsroom with this breaking news.
Mike, on a 5-4 decision, as most people predicted, the Supreme Court has in fact held that it is necessary that out-of-state marriages without necessarily issuing marriage licenses to same-sex couples is unconstitutional. They have basically upheld the right now for same-sex marriage. This is probably a surprising development to some court watchers who figured that this wasn't coming until Monday, which was going to be the last day of the session, but in fact it has come down today. And again, the Supreme Court on a 5-4 vote has said same-sex couples have the right to marry in all 50 states. The Chief Justice dissented, along with a number of other traditional Republican judges, but on a 5-4 decision, once again, Obergefell v. Hodges, which in a lot of folks' mind was the big case the Supreme Court would decide, has ruled that same-sex marriage is now legal in all 50 states. As we get more, we'll bring it to you. Back to you, Mike.
All right, Dave, thanks for that update from the newsroom. And our Scott Thuman is there outside the courthouse. We'll check in with him as soon as we can. He and many others parsing through this ruling as we get it. Scott Thuman joins us live. We see him waving at us. Scott, tell us, what do you see? What's the reaction?
Yeah, sorry for that furtive motion there, because we wanted to let you know what we are seeing now here at the Supreme Court. The cheers erupted. It was the first announcement of the day as the running of the interns, as it is called, occurred. People running down with the decision and handing them to the reporters here. The 5-4 decision in favor of gay marriage that essentially makes it now legal in all 50 states. And the argument, Mike, as you probably already discussed with your viewers here, is that it was currently okay in 36 states, but you had 4 that were really fighting it, and then a lot that were caught up in the lower courts. And had the justices gone the other way, many experts said we would be in, quote, legal chaos, because it would begin all new arguments over which states have to adhere to those previous rulings. It looks like that's a wash now. We need to look through the paperwork. But at this moment, it appears that due to that 5-4 decision, this question is put to rest, and that it is a constitutional right now to marry in all 50 states. Now, Mike, that's not to say there won't be some other future challenges, and we still have to sort out what exactly does that mean as far as discrimination law goes. What if a photographer, a wedding photographer, says it's against his or her beliefs to go ahead and be hired to do a gay marriage? Can they be sued? Are they protected under some right? So there is still a lot of legal questioning that we need to look into, and we'll have to read through a decision to see if it specifies how to handle those particular cases. But nonetheless, you have that 5-4 decision, landmark decision, the biggest crowd we have seen out here so far to date, and I'm going to challenge, unfortunately, Brian Hopkins, a photographer here, to kind of try and get you to see a little bit beyond this throng of reporters and television crews here. But there are a lot of flags and balloons and signs behind that mask, and those are the people who, for the most part, erupted with cheers today. Tough for you to see here, so we'll come back to you. But, Mike, that's the situation out here. People thought today was the day. We could tell by the amount of people who had crowded around the Supreme Court, and quite a bit of celebrating going on behind me here. But let's be fair, there are also plenty of people who are very upset about this. There were 4 states in particular who came to this court to petition against the idea of gay marriage. They thought they had very solid grounds that it should be a state decision, not a constitutional or federal one. So it's not as if all the world here at the Supreme Court is cheering. There are a lot of people who are very angry too.
Scott, as you know, we have 36 states that have already recognized same-sex marriage before this morning's ruling, as well as the District of Columbia, which about 5 years ago passed its own law recognizing same-sex marriage. But now 14 additional states in the South and the Midwest will have to stop enforcing their bans on same-sex marriage. And I'd like to just note, before we get back to Dave Lucas in the newsroom, the timing of this announcement. Today is June 26th, and it's important to note that this decision was handed down the same day, the anniversary of the other big gay cases that went before the court, Lawrence, Windsor, and now this one, Romer and Evans, the Colorado case, that was decided in May 20th, 1996. But Supreme Court decisions rarely come down on Fridays. This is the first Friday before the end of a term decision in the last 7 years. And many scholars, many court observers were watching closely. They anticipated that this might happen, Bob, because they said Justice Kennedy has a sense of theatrics, of drama. He recognized the significance of this, the significance of his role in this as the fifth and deciding vote on this court. And not only is this a vote for gay marriage, that perhaps this is a celebration, a commemoration of gay rights in our country.
I wonder if this day will become a holiday, in effect, in the future, to sort of, it would be the gay rights holiday, if this date has been so significant on multiple times.
And Justice Kennedy, an unlikely, unexpected advocate for this cause, nominated, appointed by then President Reagan, a Republican, a man that conservatives know and love, and now he is a leading figure in our history on this issue of same-sex rights.
I think the really interesting thing this week is you've got two major decisions by what is usually seen as a conservative court that the liberals are applauding. This decision, of course, today on same-sex marriage, and then yesterday's decision upholding Obamacare, upholding the Affordable Care Act. So you have this court that is usually the Roberts Court, usually seen as being conservative overall, is coming down on the liberal side on a number of big cases.
Well, let's talk about that. I want to get Scott to weigh in, because, Scott, not just the Affordable Care Act, you had the housing discrimination law that was upheld yesterday as well. You had the decision on the EPA regulating greenhouse gases. That was a win for the Obama White House. The Confederate flags are coming down across the country. Many liberals are feeling very, very positive.
Well, and I don't know that we can, look, there's kind of a gray area when we talk about whether or not it's the court shifting a little bit liberal, or is it that they are just reflecting the public sentiment a little bit more than in the past. You talked about the ruling today. You had the Pew Research poll not too long ago showing 57% of Americans were in favor of allowing gay marriage. A Gallup poll showed 60%. You look at the Affordable Care Act yesterday. You look at some of the other rulings you've just discussed. A lot of what we're seeing, and this is a bit of conjecture because we can never get truly in the minds of the Supreme Court justices, the 9 who work behind me and make these big decisions, but we would have to be able to surmise to some degree that the rulings they're making are based also on societal movement. Look, they're aware. These are people to some degree, you could argue, like anyone else, in that they're out amongst us. They have neighbors. They read the papers. They watch the news. And they also are aware of shifts in dialogue and feel. And if the overall public starts to trend one way, and it's against what something, a standard that may have been set decades ago, if not longer, you can't believe that it doesn't somehow creep into the minds of the justices. Look, it was what, only 40 plus years ago we talk about interracial marriage. I mean, the court is slow to sometimes catch up with these things, but you have to wonder if today's really progressive society, if they're starting to look at what the public is saying, and maybe it's not so much a shift to become liberal, it's maybe just a shift of following more public sentiment. And once again, that's kind of surmising what we think may be happening behind closed doors, but it's not far-fetched, and it might make sense that when you continue to see these throngs of people come out in support, they're aware of it. They look out their window, they have to drive by it, and they know when there's a movement underway that their decisions may need to reflect that movement a little bit more than in the past.
Scott, it's Dave Lucas in the studio. Can you hear me?
Yeah, I hear you.
Interesting. Our friends at SCOTUS blog just posted something that I think is interesting. This notion of a more liberal court, and perhaps we talked about this yesterday, the idea of the Chief Justice perhaps being the White House's best friend. Well, today the Chief Justice actually wrote a dissent, as did all of the 4 who voted against it. And I'm going to quote now from the Chief Justice in his dissent, which is, by the way, 31 pages long. He says, and again, thanks to SCOTUS blog for this, if you are among the many Americans of whatever sexual orientation who favor expanding same-sex marriage, by all means, celebrate today's decision. Celebrate the achievement of a desired goal. Celebrate the opportunity for a new expression of commitment to a partner. Celebrate the availability of new benefits, but do not celebrate the Constitution. It had nothing to do with it, end quote. So it gets to your point of maybe mirroring the American public more than it does, for example, constitutional law. Again, this is a dissent, but the Sixth Circuit was reversed. 5-4. The Obergefell v. Hodges case went very much in the favor of gay marriage. A little bit of perspective on what just happened there at the court.
Yeah, and I think that's a great point, Dave. And I'm gonna challenge our photographer here again to do a complete 180 here. Brian's going to turn around because we've got a choir breaking out here on the grounds of the Supreme Court with Congress right behind it, singing the national anthem. Balloons being released in the air to our right here. You know, the Chief Justice obviously foreshadowing the fact that there would be all of this celebration. But I think that you support that very theory, that maybe it's not about being liberal, it's not about the Constitution, that it's about a reflection of the growing movement in the country. And I think that's what we saw with the Affordable Care Act as well. Look, they could have hung on the technicality, those 4 words established by the state, and denied the idea of allowing federal subsidies to be for all 50 states, but instead they said that wasn't the intent. So they're looking beyond the legality of some of these measures and these arguments. David, Mike.
Just one other point, Mike, if I can, and Scott as well. The opinion appears to echo Windsor, and this is, again, we're very much in the debt of the folks at SCOTUS blog, talking about dual rationales, that marriage is a fundamental right in which homosexual couples must share, and that would also be a violation of the Equal Protection Clause to extend that right only to heterosexual couples. So a lot of people, this case was argued originally on the Equal Protection Clause of the Constitution, but in the Kennedy majority opinion, apparently they're using both that and also the fundamental right in which needs to be shared. So again, we're beginning to see a little bit of the depth and breadth of this opinion.
And you know what's interesting, Dave, is let's talk about the fact that because you always say, well, they've ruled and so this is settled, and of course we know that that's never truly the case. There are always some other challenges. You know, private religious schools, I'm sorry, not necessarily private, but religious schools who have a tax-exempt status, there are also some concerns there that they have their own rules against gay relationships in those schools in some cases. They wonder, do they lose their tax-exempt status? And I brought up the example of a wedding photographer who may object to being hired for a gay marriage or gay wedding. Same thing with bakers. I mean, there's this whole other line of challenges that may come in the future here. So truly there is a lot of sorting out still to do.